All right, welcome. The three of you who braved the mild weather to come to class today, and for those of you watching at home, this is class 11. It is Sunday, September 24th, 2014. And we're going to be covering today the separation of powers, the appointment and removal power. I'm going to just put this down. I never really put my property notes in the ConLaw section. So before we get started, are there any questions, anything in your minds from last class? Anything about the Korematsu, anything about Youngstown, anything about Hirabayashi? Anything in your minds?
So,
Yep.
Korematsu, even though it's kind of fallen out of favor, technically still stands, still is.
Yeah, so the question is, Korematsu still good law? And that's like $1 million question. It's never been formally overruled, but it's been significantly diminished. And perhaps one measure of the strength of Korematsu is that during the Guantanamo cases, the Bush administration could have cited Korematsu, but didn't. They actually went out of their way not to cite those cases. And there's a phrase that you should be familiar with in constitutional law, what's called the canon and the anti-canon. The canon are considered certain cases that are so important that people don't question them, except for me. But generally, you know, Marbury or Brown, or those sorts of, like, really McCulloch, Maryland, right? These are such foundational cases that people don't question them. Even if they're questionable, people say, okay, we're going to just go with Brown. We're going to let it go. In contrast, you have cases called the anti-canon. The canon, and you have the anti-canon. Okay? And the anti-canon are cases that, even if never overruled, have fallen into such disrepute, such shame, that if you're a competent lawyer, you should not be citing them. Even if they're good law. So I'll give you an example. Dred Scott is part of the anti-canon. Korematsu is part of the anti-canon. A case we'll study later, a case called Lochner v. New York, is a case within the anti-canon. But it still happens that people cite these cases every now and then. So it's not enough for you to simply say, oh, well, that's an anti-canon, it's a bad case. One of the stories that we tell in this class is how a case came from being, you know, a 7-2 decision to being so shameful you don't cite it. Because Korematsu was a 6-3 vote, right? It wasn't even a 5-4. So that's one of the ways that we can just separate between the canon and the anti-canon.
So that's where, they become so disfavorable that even if you could cite them, people don't.
Yeah, and I'll give you an example you haven't studied Dred Scott yet, but you'll read it in a couple weeks. And there's one passage in Dred Scott where it basically says the Declaration of Independence doesn't create any law for our country, which I think is probably wrong, but it was probably a generally accepted statement. The Solicitor General, I think of Kansas, was litigating a case involving the Declaration where someone said the Declaration gives us these rights, and they actually cited Dred Scott. And they actually had to withdraw the brief, not the entire brief, that citation. They actually had to apologize to the court. That even though it's a Supreme Court decision, was I think it's 7-2 vote or 6-3 vote, but it's considered so shameful you just don't cite it. Now, the problem with this canon anti-canon difference is just dismisses cases outright that may actually have relevant pieces in them. So one of the cases which is often dismissed is Lochner v. New York, which considers whether a New York law limiting the number of hours that bakers can work was unconstitutional. And we can say, oh, this is anti-canon, we don't cite it, but the same framework used in Lochner was used in cases involving contraception and abortion. So even if the case itself can't be cited, remnants of the case do remain. Make sense? So that's how you have to understand Korematsu, but again, it was a 6-3 decision, and the majority piled on and said, yeah, this is not only constitutional, it's a good idea because these people don't assimilate and they're not like us and they're dangerous. So it was at the time a very clear decision. It wasn't like a close call. Or it wasn't like trying to split the difference. They went full force and said, yes, Mr. President, you can do it. Okay, any questions on that? All right. So our discussion today which is broadly labeled the separation of powers, will concern aspects of Article 3, Section 2 of the Constitution. This is what's generally known as the Appointments Clause. Now, we know that there are certain positions in our government that are put there by election. We have members of Congress who stand for election. Now senators stand for election, but originally they were selected by the states. And the president and the vice president are chosen through the electoral college, right? So we have elected officials. But we have a lot of positions within government that are not elected, right? They are what we would say is appointed. And the path by which such people are appointed is the Appointments Clause. So let me read it to you. The President shall nominate and by and with the advice and consent of the Senate, shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States, whose appointments are not herein otherwise provided for, and which will be established by law. But the Congress may by law vest the appointment power of such inferior officers as they think proper in the President alone, in the courts of law, or in the heads of department. There are a lot of moving parts in that sentence. I want to break it down one provision at a time. So the first provision is the President shall nominate. What does that mean? If there's any sort of vacancy, the President has an obligation to actually try to fill the vacancy, and he can pick a name. But it's not enough for the President to pick a name and simply install the person, generally. He has to do so with the advice and consent of the Senate. What does that mean? The Senate must vote, or not vote. And if the majority of the Senate agrees, the person goes through. If the Senate does not agree, or perhaps takes no action, the person does not go through. And you most recently saw this with the nomination of Merrick Garland last year. Justice Scalia passed away in February of 2016. About a month later, President Obama put a nomination in for Merrick Garland, said to replace Scalia in the Supreme Court. The Senate Republicans never took action. They never held a hearing, no vote, or anything. And there was much argument by people saying, oh, the Senate has an obligation to vote. I don't find that persuasive. But the bottom line is because the Senate never took action on Garland's nomination, it expired at the end of the year. As a result, the vacancy remained, and then President Trump came into office and nominated Neil Gorsuch. The Senate held a hearing, they voted, gave their advice and consent, and now Judge Gorsuch is the newest justice. So the Appointments Clause applies to, again, a list of ambassadors, public ministers, consuls, judges of the Supreme Court, and all their officers of the United States, whose officers are not here, whose appointments are not otherwise here and provided. So what about lower court judges, right? The only people listed are judges of the Supreme Court. Well, Congress can provide by law for the appointment of district court judges and courts of appeals judges. What if the Secretary of State or the Secretary of the Treasury, right? These are all officers of the United States who are nominated by the President and with the advice and consent of the Senate appointed to their office, right? That part's not complicated, right? Oh, that part's pretty straightforward, I think. The next clause, right? But the Congress may provide, but the Congress may by law vest the appointment of such inferior officers as they think proper, in the President alone, in the courts of law, and in the heads of department. What does that mean? Now imagine you're an employee of the federal government. Let's say you're a letter carrier, right? Nothing wrong with being a letter carrier, but the odds are that the President doesn't care who you are, and you were probably hired by someone in HR in your local office. Are you required as a letter carrier to go to the Senate and get consent? No, it would be insane, right? The framers weren't requiring every little inferior office to go to the Senate to get confirmation. So what this Congress can do is for these inferior officers, and that's not to say that they're like stupid, right? Inferior just means lower, right? Subordinate. For inferior officers, they can let the President appoint the person by himself, or in the heads of departments. So if you're the Secretary of the Treasury, you can hire your staff. If you're the U.S. Postmaster General, you can hire your staff. And you can delegate that. You can say, okay, you're a supervisor in Houston, I'll let you hire a couple of letter carriers. This also applies to the courts of law, right? What if, one of you wants to be a federal law clerk one day? I hope you all do. Does the President need to nominate you as a federal law clerk? Of course not, right? The judges of the courts are empowered to hire law clerks and other staff for their position. So the Appointments Clause provides the method by which officers of the United States are nominated and appointed. There's something missing though, right? Does the President have the power to remove judges, officers of the United States, the Secretary of the Senate, Secretary of State? So we know for sure that the President can't remove judges. Judges are subject to the impeachment process, so that's out. What the President wants to fire is Secretary of State, or his Secretary of the Treasury, or his FBI Director. Right? What the President wants to fire the FBI Director. Is there anything in the Constitution that says that the President has the power to remove? You can read it. I've been reading it for many years. It's not there, right? Nothing in the Constitution actually says the President has the removal power. But this was an issue that was fiercely contested from the earliest days of our Congress. So back during the Washington administration, right, very beginning, Congress considers a statute that would say the President needs the Senate's consent to remove some officers, right? He needs consent to appoint them in the front end, and the back end, if he wants to fire them, he needs the Senate's consent. By a single vote in the Senate rejected this proposition. It doesn't set any sort of legal precedent, but establishes a tradition that the President doesn't need the Senate's consent to do this. Now, who was the single vote? It was the Vice President. It was a tie in the Senate. And Vice President John Adams broke the tie, holding that the Senate cannot require the President's consent. But this didn't resolve the issue. This issue didn't come to a head till the Civil War. After the assassination of President Lincoln, President Johnson took over. Well, it was Vice President Johnson became President Johnson. And President Johnson was a sympathizer of the South. And he opposed Reconstruction. He didn't believe in it, as did Lincoln. So one of Johnson's first actions was to try to fire Lincoln's Secretary of War, who was a holdover. And he said, "You're fired, Mr. Secretary of War." The problem is the statute that was in effect at the time said the President could not fire the Secretary of War without the Senate's consent. This is a crazy situation where the Secretary of War refused to be removed. He basically locked himself up and said, "If you come and try to get me, I'll arrest you." Right? This was what's called the Tenure of Office Act. Right? Congress passed a law, the Tenure of Office Act, saying that the Senate must consent to the removal of the Secretary of War. Johnson fired him anyway, and eventually he gave up his office. But then the Senate tried to impeach him. The House tried to impeach him and said, "You broke the Constitution. You violated this Tenure of Office Act. You violated the Tenure of Office Act. All right? You're not allowed to fire this guy without our permission." This was the article of impeachment. So if you want to understand how significant the removal power is, the first impeachment of a U.S. president concerned removal power. This is a really big deal. The House voted to remove Johnson, and by a single vote in the Senate, only one vote, he was acquitted. Had one more vote gone the other way, President Johnson would have been removed from office. It's unclear how history would have gone that way. But this didn't resolve the legal issue, right? Because as far as the Senate was concerned, they could require the President to seek consent when firing an officer. This issue would not come to the Supreme Court until some years later, in a case called Myers versus United States in the 1920s, M-Y-E-R-S. I didn't assign it anymore, but it's mentioned in Morrison. And under the rule in Myers, right, this is an opinion by Chief Justice Taft, who was formerly the President can remove officers at will. He doesn't need the Senate's consent. So what happened was you had a postmaster, right, I think Oregon or somewhere out west. And the President, I think it was Wilson, came in and said, "Okay, Mr. Postmaster, that's nice. I'm going to fire you because I want to put my own crony in that spot," right? That's one of the patronage of the job, right? You get into office, you put your own postmasters in. And the postmaster said, no, I have a tenure, I have a fixed term, you can't fire me like this. The Supreme Court held in a very long opinion that I think was correct, that officers like the postmaster are within the executive branch, and they can be removed at will. They can be removed at will. So you would think that this settled the issue of the Tenure of Office Act, right? If they can remove officers at will, then, you know, what's the big deal? But about a decade later, in 1934, you had the case called Humphrey's Executor. Humphrey's Executor. Humphrey's, Humphrey's Executor. And that considered whether President Roosevelt could remove a commissioner on the Federal Trade Commission. Now, you may ask, Josh, what's a commission? So during the New Deal, these new federal agencies were created that weren't traditional. They weren't headed by a single person. Instead, they usually had 5-member boards. 3 members appointed by the president's party, and the other 2 members appointed by the opposite party. So with 3 Democrats and 2 Republicans, as it were. And the statute that created this agency said the president can only remove commissioners for good cause, right? He can't just remove them because he doesn't like them or has a different opinion. There has to be good cause. And what's good cause? Breaking the law, malfeasance, you know, doing something stupid. Roosevelt went to Mr. Humphreys and said, hey, that's nice that you were appointed by President Hoover. I want you out. Leave. And Humphrey said, screw you, I'm not going anywhere. So then Roosevelt fired him and put someone else in his place. Now Humphrey sued for his return of salary. He said, look, I have this position for X number of years. I want my salary. I should still keep getting. Now he actually died in the middle of the case, and how he died, I'm still trying to figure out. It's unclear. I actually got emailed randomly because he watched my lectures like, I found Humphrey's obituary. And he said he would email me a copy, but he hasn't done it yet. So when I get his obituary, I will report it back to you. But every year, like, I don't know how he died. I can't figure it out. I'm not suggesting Roosevelt killed him, but it was just weird he died that quickly. So eventually, his estate, right, his executor sued Roosevelt for the lost salary. And this goes to the Supreme Court. And you might say, well, look, under the rule in Myers, this is easy, right? The president can fire anyone at will, right? The postmaster, the FTC, there's no difference. But the court in Humphreys creates a new rule. They create a new rule. And the new rule is that for certain quasi-legislative and quasi-judicial officers, the president does not have complete removal power. That Congress created these offices with independence, to be separated, to be insulated from the executive branch. And as a result, the president can't remove them at will. So they actually ruled against Roosevelt. Was this a correct ruling? If you read Justice Scalia in Morrison, he says this was an activist ruling of the court trying to stop Roosevelt. He's probably right. He's probably right about that. But this was the rule for decades, that the president could remove purely executive officers at will, but officers who were independent with this quasi-legislative and quasi-judicial powers, they couldn't. And what do I mean by quasi-legislative and quasi-judicial? If you go to an agency, they kind of act like judges in that they can actually hear cases and make decisions. And they make these things called rules and regulations. A regulation is not a statute. It doesn't go through Congress. But these agencies acting pursuant to authority from Congress basically write effective laws. When you see a regulation or a rule, this comes from this agency. So they have executive powers, they have legislative powers, and they have judicial powers. And you may say, Josh, wait a minute, isn't the separation of powers that keep everything separate? That's Scalia and Morrison. He said you can't have this merging of these various branches. Now, Scalia is not willing to go back and overturn Humphrey's executive. He probably thinks it was wrongly decided. He'll accept it as settled law. But the entire notion of an independent agency is not consistent with the separation of powers. It simply is not. It isn't. But that's part of our law. So that brings you more or less till the 1970s, right? Where the rule is purely executive offices can be removed by the president unilaterally, but Congress can impose conditions on the removal of so-called independent agencies, whether through a quasi-legislative or quasi-judicial function, and that generally means good cause. You have to give a cause to fire them. You can't just do it on a whim because you don't like the guy. How's that? Questions? I summarized 150 years in a couple minutes. That worked out for you. Brittany, Dan, David, any questions? By the way, there are three people here. I'm looking at you, camera. Any questions, guys?
It still strikes me as, very against the separation of powers. That Congress can create, in essence, a body that's above everybody else. That they can create one that's above the judiciary, above the president, even above Congress themselves.
So the reason why I think the courts have blessed this is the recognition that Congress made the decision that they can't rely on partisans to make certain types of policy. So you have the Federal Trade Commission, you have the Securities Exchange Commission. Any agency that ends in commission means it's a 5-member block. And the idea is they don't want a single president to control those areas. The flip side to that is you have this sort of fourth branch of government that's floating around that is not really accountable. And the courts are still coming to grips with the implications of giving these agencies such vast authority. And there's another question which you'll study in administrative law. The courts defer to their decision, right? So if Congress passes a statute that's ambiguous, and an agency interprets it in an absolutely insane way, the courts have to follow it, but the courts independently judge whether it's correct or not.
Also too, I mean, usually the redress for the people is like, hey, if you don't like something, you can change the elected official. But then if the elected official can't actually change that body, then the people have to.
Which is a perfect segue to the first case, right? Generally, civil servants working in department of you name it can't be fired. Generally, you don't know who they are. You have no idea who's making your rules. You have no idea who's governing you. But the issue in the first case, Morrison v. Olson, is a case where not even the president can remove a prosecutor if he wants to. Right? That's what's going on in the first case. So we'll come back to the appointments clause when we do Milkaddin later in class. But let me walk you through what happened. And this was a very important. Where's it here? This is a very important sequence of events that most people don't understand. And in recent months, this story has become relevant, and I can't count how many smart people have misreported this story. I was on NPR, maybe it was BBC World Service, I can't remember, I was correcting the host. Like, no, that's not really, I know, I teach this in class. It's funny, because I'd actually taught in class Marcy Bilson, I think, like a week before President Trump fired Sally Yates. So I had just taught it, and it was like fresh in my mind, so I was ready to roll. I try not to make this class a current events class, because otherwise we won't do anything. But this is a case where it is overlapping. So, in 1972, President Nixon was up for re-election. And there was this group called the Committee for the Re-election of the President, CRP, or CREEP, as its critics call it, right? If you're going to name an acronym, spell it out. For example, my beloved law school was recently renamed the Scalias School of Law, asshole. So they changed it to the Scalia Law School, assless. I mean, you're damned if you do, but at least spell out your acronyms when you come up with the hashtag. Anyway, so in 1972, the campaign hired burglars to break into the Watergate Hotel, and the Watergate Hotel was the location of the Democratic National Committee. What they were looking for to this day is not exactly clear. I'm sure they had some reason, but it's not exactly clear what happened. So Nixon was reelected in a landslide, right? He had huge, I think he had 46 or 47 states. It was an absolute wash. But after the election, it started to become clear that the White House had some involvement in this break-in to the Watergate Hotel. So Nixon's Attorney General, a guy named Archibald Cox, I'm sorry, Nixon's Attorney General, Elliot Richardson, had told the Senate, all right, don't worry, I'm going to appoint a special prosecutor, all right? He said, I'll appoint a special counsel to investigate this. That's important because Richardson personally promised the Senate, I'm going to do this, okay? The first counsel they appointed was Archibald Cox, who was a Harvard law professor. And then Cox soon learned of a secret tape recording system in the White House. He issued a subpoena to the White House requesting the tapes. Nixon refused, and Nixon ordered the Attorney General to fire Cox. Now, this wasn't a mystery, right? Everyone knew this was coming. If you read the discussion in the book, but they knew this conflict was going to happen, but it happened on a Saturday night. So Richardson refused to fire the special counsel, and he resigned in protest. Okay, so then, as you know, there's a hierarchy. So then the number 2 guy got promoted. That was William Ruckelshaus. And Nixon said, fire Cox. And Ruckelshaus refused and resigned as well. Third in line at DOJ was the Solicitor General Robert Bork. And at this point, he was now the acting head of the Justice Department. Now, he knew this was coming. he had actually talked with Richardson and Ruckelshaus, and basically Richardson said, you need to fire him, because if you don't, it's going to just blow up, because you'll keep firing one down the next, down the next. So Bork made a very momentous decision that would probably cost him a Supreme Court seat decades later, to fire Cox. Bork agreed that Nixon had the power to do this, but he said he didn't want to be perceived as just doing the president's bidding to save my job. In fact, after he did this, he was basically acting head of DOJ, and with that comes certain perks. You get a driver, you get a car, and Bork said he refused to take the driver and car. He didn't even want to acknowledge that he was now the head of the Justice Department. It's a funny story because he had this old beat-up Volvo with a 2-cylinder engine, and he could barely make it up the ramp in the garage. But he declined the black car driver. Okay, so Cox was fired. This sequence of events became known as the Saturday Night Massacre because it happened on Saturday, October 20th, 1973. And you can go look at this graphic later. It's actually quite helpful to figure what happened. But that didn't end the controversy, as I'm sure you're aware. Firing the special counsel doesn't really make things better. Nixon perhaps thought it did. He misjudged. So after some time, a second special counsel was appointed, a guy named Leon Jaworski. And eventually, Jaworski kept digging, and he demanded the tapes. The Supreme Court, in a case called U.S. v. Nixon, ruled that the president had to turn over the tapes. He had to. Shortly after that decision, the president announced he would resign, effective August 9th, or whatever it was, the following day, August 9th of 1974. So he stepped down from office. You've seen the picture. He hopped into the Air Force, or actually Marine One, and put his V fingers up. So this case illustrates at once the importance of the removal power. Nixon tried to fire the guy looking into his dirty laundry, and it came back to bite him in the ass. And eventually, it came out what he was trying to do. But the fact is, he had still been able to appoint a special counsel, and had he not appointed Jaworski as the second one, it's unclear if this would have ever come to pass. So in 1978, Congress enacts the Ethics in Government Act, EIGA. And this is the subject of the case in Morrison against Olson. And the Ethics in Government Act, broadly speaking, allows for the appointment of a special counsel, or a special prosecutor, by the courts. And it's a fairly complicated process. We'll go through it when we do the facts. But the key point is the president can't remove the prosecutor at a whim. He can only remove him for cause. And truly, the Attorney General has to remove him. Right? So the preview, long and short of it, is that the statute is no longer on the books. But as a matter of precedent, it's very important. Because as it stands today, there are certain regulations that restrict the president's power to fire a special counsel. That's Robert Mueller, who's investigating Russia. This case was 7-1 with only Scalia in dissent. If I had taught this case last year, I would have said to you without any question, Scalia was right. Scalia got it right. And most people would agree with this. But since the events of the last 7 or 8 months, people have changed their minds. Now say, no, Scalia was wrong. We need to be able to have a special counsel that can't be fired. So even though the independent counsel statute, the Ethics in Government Act, has been phased out, the question of whether Scalia was right and whether the executive has to follow Rehnquist, majority, or Scalia dissent, this is a live issue. It's a live issue, and I gave you an article I wrote on this a few months ago because I knew this was coming. I don't think we'll see the president attempt to fire the special counsel without cause, but he can. He may. And the question becomes, is that lawful? Does Robert Mueller go to court and sue for a salary to say that you can't remove me from office? If you think the last 7 months have been a wild ride, hang on. I've talked enough for 30 minutes. Any questions about this so far? We'll do Morrison in a minute. Sorry, this is a case where I have to give a lot more background because it's not. All these people said, oh, Nixon fired the special counsel. He didn't fire him. He had his subordinates do it. I can't count how many really smart people said, Nixon fired. No, his subordinate did it. The reason why is because he couldn't do it himself. The reg said only the AG could do it, the Attorney General. So a lot of really smart people could clown themselves with this episode, and I was there to clean up the mess.
During the Civil War Tenure Act, Johnson fired the secretary only after Congress passed that act, right?
Well, the statute had been passed some years earlier, yeah.
Oh, it was passed earlier?
Basically, when Lincoln appointed, his name was Stanton. When Lincoln appointed Stanton as the Secretary of War, he appointed pursuant to the Tenure in Office Act. So that his office was basically created with this limitation on it.
Okay. Because if there's not like a clear,
In the absence of a statute, it's fine. But if Congress adds that requirement, that's where the issue arises.
right, so would it be unconstitutional if, to remove somebody in the absence of, or if Congress specifically,
If Congress is silent on it, then the President can remove at will.
that's what I'm, yeah.
The question is what happens if Congress puts restrictions on removal. This is the Morrison case we have right here.
Because the powers come from not just the Constitution, but also from Congress.
Well, again, let's look at the Appointments Clause. It's silent on removal.
Right.
So this is a case where it's generally understood the power to appoint necessarily requires the power to remove. And let me give you an example of why. I like the way you put your question. The President has a duty to take care that the laws are faithfully executed. What if his Secretary of War was a holdover, is being a jerk, and refuses to do anything, right? The President says, go invade that country, right? Go do this. And the Secretary's like, nah, not going to do it. And the President's like, I'm going to fire you. It's like, no, you can't. You have to go to Congress. The President's ability to take care that the laws are faithfully executed depends on his subordinates following in line. And if his subordinates resist him, at that point, he can't execute his oath of office, and he can't faithfully execute the laws. So the removal power is not enumerated, but I think it's best understood to derive from the take care clause. Okay, any questions on that? So let me give you some more background. The case Marcy Bilson, right? So who's Morrison, who's Olson? Olson was the Assistant Attorney General for the Office of Legal Counsel. This is actually a great story. So during the early 1980s, there was an investigation into the Superfund, which is like this massive place where like toxic waste is stored. And Congress requested that the government turn over certain documents concerning the Superfund. Ted Olson advised the administrator of the EPA to not turn over these documents because of executive privilege. Do you know who the Secretary of the EPA was? Anne Burford Gorsuch. Neil Gorsuch's mom was the administrator of the EPA, and she was the one who was advised not to turn over these documents. The House then held her in contempt. And they also tried to hold Ted Olson in contempt, saying that he lied to Congress in testimony. So some years later, after they issued this like 3,000-page report, the Congress made a request to the Attorney General to appoint a special counsel, right? Now, let's walk through this. Brittany, what's the process by which a special independent counsel can be appointed?
Okay.
Let's walk through this process, it's important.
Oh God. Did I write all of it? It was, the Attorney General, does an investigation, right? Or 90 days, one of the two.
Well, what's the Attorney General required to do once the,
To determine
once
if there's
Congress makes the
sufficient-
request?
If there's sufficient grounds.
Good, I think that's the key standard, right? If the Attorney General receives information that there's, quote, sufficient grounds to investigate whether someone may have violated the law, he must conduct an investigation. Is that a high standard, Brittany? No, it's a very low standard. Basically, if there's something there, that there's even a remote possibility that this guy broke the law, he has to investigate. Okay?
Mm-hmm.
But once the AG begins the investigation, he has to do something very specific. He must report to the special division. This is a special court that's created for the sole purpose of appointing special counsels, independent counsels. So after the AG's 90-day investigation, he has to give a report to the special counsel. Okay? If the Attorney General determines that there's no reasonable grounds to believe that a further investigation is warranted, he must notify the special division. But in any event, If he does determine that there is reasonable ground to proceed, he must apply to the court to appoint a special independent counsel. And again, this is a very low standard. This is not a high standard. So if the AG says there's something there, he basically asks this 3-judge panel to appoint a special prosecutor. Okay? Once the AG receives this application, they have no choice. They're required to appoint a special counsel and define that counsel's jurisdiction, what they can and cannot investigate. Okay? Now, this position is very powerful. As Justice Scalia says, even though you're the ambassador to Luxembourg, right, you're still the ambassador to a country that's a small country. And the counsel has full power and independent authority to exercise all prosecutorial functions. They can convene a grand jury. What does that mean? They can charge them with a crime. In other words, the independent counsel here is Alexa Morrison, who actually argued the case on my own behalf. Alexa Morrison independently charged Ted Olson with a grand jury indictment. And during this time, the Attorney General is required to suspend all investigations. So the AG can't frustrate it. They have to let the independent counsel go. How long does she stay under task for? Basically as long as she wants. Until she decides that basically all the leads have been followed, she keeps going. And her budget is actually quite large. Now, how can independent counsel be removed? Well, they can be impeached, or they can be removed from office for good cause, mental disability, mental capacity, or another condition that substantially impairs their duties. So long as she's not like comatose, right, and as long as she doesn't break the law, she can't be removed. She cannot be removed. It's possible that when her investigation is complete, the court can terminate her investigation, but it's not clear if that would actually happen. So here we have Morrison, and she was appointed to investigate whether Ted Olson lied to the government, lied to Congress. So this is like a separation of powers, like a final exam question, because it involves like basically everything in one spot. So the first question we have to ask ourselves, David, this person is appointed by the courts, right, not the president. How does this fit under the Appointments Clause? Where does Ms. Morrison fit under the Appointments Clause? How can she be appointed by the courts, not the president? I mean, nominated by the courts, not the president.
From the Appointments Clause, I mean, you'd have to classify her as an inferior officer.
Yes, exactly right. So that's the first part of the court's opinion, right? It's obvious that she's not appointed by the president and confirmed by the Senate. There's no doubt. So if she was a principal officer, principal is the opposite of inferior. If she was a principal officer, this case would be over really quick. So the court first says that she's an inferior officer. And as an inferior officer, Congress can vest in the courts of law the power to appoint her by law, right? Congress can allow the courts to appoint this inferior officer. Now, David, why does the majority say that she's inferior?
They said she was inferior because of a few reasons. Like,
okay.
One was her jurisdiction, one was her tenure, and one was that she was answerable to someone else, like from the removal clause.
Very good.
They listed in the statute.
Very good. So the court first finds that the independent counsel is an inferior officer, and they say, look, her tenure is limited to a certain investigation, her jurisdiction is constrained, and she can be removed. This is an amazing holding because there's very little that's inferior about her. She has a very broad power to basically take down a president. And indeed, years later, in the Watergate investigation, Judge Ken Starr, who was the independent counsel, nearly brought down a presidency. It led to an impeachment and almost removal. Okay? So first the court says, fine, she's an inferior officer, right? But then the question concerns removal. She can only be removed for cause, right? Now, I mentioned a moment ago that in the case of Humphrey's executor, they said, if a position is quasi-legislative or quasi-judicial, Congress can impose limitations on that position. However, if it's purely executive, the court said in Humphrey, the president can remove them at will. Daniel, isn't a prosecutor purely executive? Why, how does the majority square this one? If this is a prosecutor, how can they not be purely executive?
Well, they weren't.
How does the court follow Humphreys
They
here?
weren't appointed by the executive.
I'm sorry?
They weren't appointed by the executive.
Well, but their function is purely executive. They're prosecutors, not a quintessential executive branch function.
Yes.
So then how does the court distinguish away Humphrey's executor? What did they do?
Well, they say that if it's so central to the function of the executive branch,
Is that consistent with Humphrey's executor?
no,
No. So what do they basically do there?
they created him.
Yeah, they overturn Humphreys, right? It's very, and Scalia makes the point, I think, very lucidly. It's very hard to read their reading of Humphreys, anything but overturning it. They're saying, well, it doesn't matter if it's purely executive. Let's be general, let's look what works for government. If the government wants to put this removal power, that's okay. And this is an important provision, right? As they say, as a result, there's no violation of separation of powers. It's undeniable that this reduces the control of the Attorney General, right? But they still have some control. And if Congress wants to give this independent agency this power, they can do so. What do you think of this majority holding? Does it seem comfortable in its own skin? Like, does this majority opinion seem like it's comfortable with what they're doing here?
No.
Why not?
I think kind of for the reasons that, because they're trying to say that the president still has sufficient control over these duties, but yet Scalia points it out in his dissent that all executive power is vested in a president, so this should just be void. We shouldn't even be going through
Yeah,
this.
one of my favorite lines from Scalia is it basically turns shackles into helping something into locomotion, right?
Yeah.
So again, this case is 7-1, but I think you have to understand it against the background. This was passed after Watergate, right? This is maybe, 10 years after Watergate, 15 years after Watergate. This was fresh in their minds. And they saw the danger of what happens when you have an executive who can just fire prosecutors at will. And I'd be willing to put money on that the justice said, we don't want to be responsible for stopping this. That if Congress is comfortable with having these investigations, that's for Congress to decide. The fact is, though, after Marcy Bilson, which upheld the statute, President Clinton, when he was in office, had an independent counsel investigate him and Hillary. And they investigated, they started off with something stupid, Whitewater, right? It was this real estate speculation deal. I don't remember what it was about. But soon the Whitewater investigation expanded to Bill Clinton's sex affairs. And Monica Lewinsky. And I did not have sexual relations with that woman, Miss Lewinsky, and interns. And the investigation just ballooned from one to the next until the House of Representatives impeached the president over his contempt of court. He basically lied in court. Senate didn't remove him, not even close. Didn't have nearly enough to have 2/3. But after the Watergate, the Whitewater experience with Ken Starr, there was a general sense of, okay, this law is a bad idea, right? We should not have this. And so they let it expire, right? The law has to be renewed every so many years. And instead they put these regulations in place that approximate the Independent Ethics in Government Act, but not exactly. And for years, whenever I taught this case, people said, oh man, Scalia's right. Yeah, Scalia had the better argument. But in the last 7 months, you've had calls from Congress who appointed a new special counsel to investigate President Trump. So everything that's old is new again. And let's go through Scalia's dissent. Putting aside the fact I think this dissent's correct, it's probably one of the best written dissents ever. Ever. It's so beautiful to read. I miss him, especially when I read this case. And Justice Kagan, who doesn't agree with him often enough, said that this opinion gets better every year. Not that it's right, but that the writing is so good. And the opinion begins, we are a government of laws and not of men. And this is a phrase which I think I've mentioned, most students never hear it. But it comes from the Article 30 of the Massachusetts Constitution of 1780, authored by John Adams. And it says, the judicial should never exercise the legislative and executive powers for either of them. But to that end, it may be a government of laws and not of men. What Scalia is saying is the separation of powers don't exist merely as formal structures. They exist to protect our individual freedoms. And in particular, whose freedom was being screwed here? Ted Olson. He was basically being prosecuted by this unchained independent counsel who could be stopped at nothing. Ditto Bill Clinton with Ken Starr, right? Nothing could stop Ken Starr. And even Ken Starr has come out and said it's a bad idea to have the statute. He and his associates recognized in hindsight this was not a good idea. But Scalia would often explain that what makes our Constitution unique is not the Bill of Rights. Every country in the world has a Bill of Rights. What makes our country unique is the separation of powers, that each branch can check the other branch. As Madison said, ambition can counteract ambition. And because you have the executive checking the legislative and so forth, you keep things more or less in stasis. But this is not that. He writes, frequently an issue of this sort will come before the court clad, so to speak, in sheep's clothing. The potential of the assertive principle to effect important change in the equilibrium of power is not immediately evident and must be discerned by a careful and perceptive analysis. My favorite line. But this wolf comes as a wolf. If you ever come to my office, I have a Scalia bobblehead, and he actually has a little wolf on it, among other things. So Scalia says that this investigation, which was 3 years and has thousands of pages of reportings, began because you had a Congress that hated the president, right? This began because you had a Democratic-controlled Congress that opposed President Reagan, which is basically what we're having in a couple months, right? And because of this, they were able to appoint and have appointed this independent counsel. And I'm not saying Morrison was bad, but she was given a task of finding anything she could without any resources, anything to stop her. Scalia says that we have to resolve this case by looking to the Constitution. The executive power shall be vested in a president. 1, unitary. The notion is that we have a unitary executive and all the executive powers are in his control. The president can't delegate to Congress executive powers. Congress can't delegate to the president the power to make laws. This is what's at the center of separation of powers. Scalia says, does the statute deprive the president of exclusive power? Of course it does. Sure, the AG has some control, but that's like referring to shackles as effective means of locomotion. The good cause standard is an impediment, not a grant of control. And he even speculates, what happens if there was a statute that allowed Congress to resolve cases if they were judges, right? Spread the judicial power out to Congress. That statute would not go very far. Okay? At bottom, why do we have the separation of powers? Liberty. While the separation of powers may prevent us from righting every wrong, it does so in order to ensure that we do not lose liberty. Right? Long before the Ethics in Government Act, there were special prosecutors. But here, the court errs. So Scalia's opinion basically is not rebutted. The majority doesn't even bother responding because they have no response. This is actually a mark of how you know the dissent's probably better. The majority can't acknowledge it. They don't even mention it. You'll see this a lot with Justice Kennedy, where he writes his lofty philosophical treatises on who knows what, and Justice Scalia is ripping him in dissent, and it's like, beneath me, right? I won't deign to respond. There's a cost when you don't respond to the dissent, because when law students read, it's like, wait a minute, where's the response, right? You're law students, you want to see what's the other side of the issue. There's no response. So first, Scalia says the notion that this is an inferior officer is insane, right? She has a full breadth of the U.S. government's power to investigate. She can charge people, do whatever she wishes. If this is not a principal officer, then nothing is. Okay. Next, Scalia notes that the court overruled Humphreys. We've long had the standard where if you're a quasi-judicial, quasi-legislative official, the president could not remove you without cause. But now, even if it's a purely executive official, the president still can't remove you without cause. So that basically sweeps Humphrey's executive to the dustbin of repudiated constitutional principles. What's the court's line? Trust us, right? Trust us. We'll make sure you can accomplish your job. Scalia writes, I think the Constitution gives the president and the people more protection than that. Okay. And Scalia raises a point that you may not quite agree with as much, but it's worth developing, that a check on the prosecutor's power is political pressure, right? often Nixon appointed a special counsel, even if he didn't want to, because of political pressure, right? Political pressure is just as good as these sorts of ethics and government acts to ensure that prosecutors can investigate. But the independent counsel statute screws up political accountability. It screws it up royally, okay? Because now, who do you blame, right? Morrison's doing her thing, investigating, and then it's creating all these problems for President Reagan. Can the president fire her? Can the people vote against Morrison? She's totally insulated. So this distorts who's responsible for blaming. Scalia calls Morrison the mini executive. Okay? And he closes noting, like it or not, the Constitution provides a rule of decision. The executive powers will be vested in A, one, President of the United States, and that's enough to resolve the case. So Marcy Bilson is a difficult case for me to teach because, at least until Trump was elected, it was obvious Scalia was right. Now people are second guessing that because they're afraid of Trump. But the reasoning in Scalia's opinion is far more consistent with the court's other separation of powers decisions. And they go back and forth on this. But the question becomes, if President Trump tries to fire Robert Mueller and have his Attorney General fire him without cause, this will get litigated. And Trump will have to argue that Scalia was right. And would a president go to the Supreme Court and say, yeah, it was a 7-1 decision, but the dissent was correct? Ooh, I would. I'll argue that. I've argued that vociferously. I think Scalia was right. But precedent is precedent. By the way, before the election of 2016, I was pretty confident there were 5 votes overturn Morrison. After the election, I don't know. But I was pretty confident before the election that was the case. All right, so questions on Morrison, Olson. Questions on Morrison, Olson. Question for you at home? Oh, just kidding, you didn't come to class. You can't ask questions. Kidding, kidding, kidding. You can email me later. That's fine. I think there are 5 or 6 people watching right now, which is nice. Anything in your minds? All right. Under Morrison, the special counsel is an inferior officer. Even though she's a pretty executive function, it doesn't matter. So at this point, it's trust us. That's Scalia's right.
I mean, doesn't it go kind of past the point where, with President Johnson, I mean, if the president fires somebody and everybody's like, oh, that's wrong, they can impeach him.
They can.
I mean, there was already a mechanism built into the Constitution.
But they impeached him for what? Violating the Tenure of Office Act. Johnson defended himself saying the statute's unconstitutional, right? If the Tenure in Office Act was unconstitutional, he couldn't be impeached because he followed the law, right? The ground for impeachment was breaking the law, but if the statute was void, he broke no law. So actually, the centrality of Johnson's impeachment hearing was about whether the Tenure of Office Act was constitutional. That was a central issue. Understand?
I understand that. I mean, with the whole idea of if a president fires a special counsel, I mean, you wouldn't necessarily be impeaching him on the grounds that he removed this person. You're impeaching him on the grounds that he broke the law.
What law?
Like, I mean, it just hypothetically, like.
But if he can remove
because the special counsel theoretically is investigating.
Yeah, but if that statute's if the Ethics and Government Act is unconstitutional, you can't impeach him, right? I mean, you can impeach a president for whatever you want, but it's not a very good case. If the statute preventing him from firing the special counsel is unconstitutional, then he can't be impeached for violating that statute. Understand that point? Right? The reason why Johnson was almost impeached or almost removed, he was impeached. The reason why Johnson was almost removed was because the Senate argued that this statute was valid. So if the Congress tries to impeach Trump for firing Robert Mueller, Trump will say, no, I had the power to fire him. Scalia was right. I expect this to happen at some point. I don't know quite when, but I'm ready. And you are all ready too. You will be informed citizens.
But so in impeaching the president, I mean, isn't it for Congress to make the investigation if somebody broke the law?
Right.
If the president broke the law, not necessarily.
So this gets the standard for impeachment, right? What are the standards for impeachment? High crimes and misdemeanors. What does that mean? Can Congress make whatever it wants an impeachable offense? So Jerry Ford, who was the vice president and he was the Speaker of the House and became president, famously said, high crimes and misdemeanors means whatever Congress wants it to mean. So if they want to say the president was involved in corruption or whatever else, they can do that. But the specific charge against Johnson was that he broke the statute, and that was a specific issue. So if Congress tries to remove Trump for firing Mueller, and Trump says the restrictions on firing him are unconstitutional, the Senate actually votes on that, right? Not all constitutional laws are decided by the courts. The Senate, when they're hearing your impeachment trial, is legitimately a trial. Each member of the Senate is a judge, and they have to vote on each article of impeachment. And they have to make the decision that, yes, we think Scalia was right, or we think Scalia was wrong. Understand? It's actually a hearing. In fact, when the president's being impeached, it's presided over by the Chief Justice of the United States. All right? To make sure that it's done in an appropriate fashion. Scratch your brain for a second. If it's a usual impeachment ceremony or a hearing, the vice president presides. What if the vice president's being impeached? Can he preside his own impeachment trial? Whoa. This goes deep. Think about that for a minute. Questions? All right, let's move on to Noel Canning. This is a fairly recent case, I guess 2014, it's about 2 or 3 years ago. And it's an important case because it illustrates what happens when the branches of government don't function as well as they ought to. So I'll give you a little shtick. This is one of my shtick talks, but I'll give you a little shtick. Let's see. So the National Labor Relations Board is a executive branch agency with 5 members, right? This is like a commission, it has 5 members. 3 members are appointed by the president's party, 2 members are of the other party. So, when the Republicans in office, there are 3 Republicans, and when there's a Democrat in office, there are 3 Democrats. But one of the strategies used to cripple this board was to block appointments, right? If the commission ever falls below 3 members, right, at one point they were down to 2 members, they can't issue any decisions. And if the labor board can't issue any decisions, it can't hurt businesses, they can't hurt unions, depending who's in power. So, during the Bush administration, the strategy was to simply block the nominations of any members of the board. They would filibuster their nominations. And then during the Obama administration, it basically continued. They would block nominations of the board. So the board fell down to 2 members, these 2 lonely people this whole way, right? Okay, this was gridlock in its most natural form. President Obama tried to appoint this guy, his name was Craig Becker, to the National Labor Relations Board, and that created a massive fight. Indeed, there was all these phone calls and commercials saying, tell your senator to vote against Craig Becker, like filibuster and block him, right? So that put the board in a tough spot. Why? They were about to fall under 3 members again. And once they fell under 3 members, they'd lose their quorum and they can't make any decisions. So what did President Obama do? He turned to recess appointment clause. So let's go back. Where is it? I can put it up here. Okay, 1 second. Sorry, can't get it in advance. So there's another provision also in Article 3, Section 2 called the Recess Appointment Clause. And it says, the President shall have power to fill up all vacancies that may happen during the recess of the Senate by granting commissions which shall expire at the end of the next session. So what's the difference between the first paragraph and the second? Well, the biggest difference is the President can fill vacancies without the advice and consent of the Senate. He can do it unilaterally. But he can only do it under certain circumstances. 1, the vacancies that may happen during the recess of the Senate. Now, what does that mean? Does that mean he can only fill positions that become vacant during the Christmas break? Or if the vacancy existed before the break? What is the recess of the Senate? Is that when they go home for lunch for a couple hours, they come back the next day? Or is that the break between 2 sessions? How long does a break have to be to constitute a recess? These are tough questions that have been resolved for decades, if not centuries. So the president, I'll show you the video, decided that he was going to appoint members of the National Labor Relations Board in January of 2017. Okay? So I want to show you a video. It was January 3rd. This is a session of the Senate. Ready? If you blink, you'll miss it. So what the Senate often does...
The Senate will come to order.
Got to pause it for a second. What the Senate often does when they don't want to go into recess is they'll have one member of Congress, usually from Virginia or Maryland, come in, gavel a session in, speak for about 5 or 6 seconds, and gavel out. And the purpose of this is to keep in session but have breaks between the sessions. So let me play this again. You're going to miss it. January 3rd, 2012. 12:01 p.m.
The Senate will come to order. Pursuant to the Constitution, the hour of 12 noon, January 3rd, having arrived, the Senate convenes the second session of the 112th Congress. The clerk will read a communication to the Senate.
Washington, D.C., January
No one's there. It's empty, right? Totally empty room.
Senate. Under provisions of Rule 1, Paragraph 3 of the Standing Rules of the Senate, I hereby appoint the Honorable Mark R. Warner, a senator from the Commonwealth of Virginia, to perform the duties of the chair. Signed, Daniel K. Noel, present for temporary.
Under the previous order, the Senate now stands adjourned until 11 a.m.
That's it. That's it. So what do we make of that, right? Well, during this period, after Senator Warner made this little spiel, President Obama made a recess appointment. So again, the session began on, was it January 3rd, I think? January 3rd, right? So on January 3rd, you have this pro forma session, and you have another session, the exact same thing, this 30-second session on January 6th. So there was a 72-hour gap between these pro forma sessions. And it was during this time that the president made appointments to the labor board, right? Was this constitutional? Was this valid? The president had an opinion from the Office of Legal Counsel, opinion that we reversed 9-0, but he appointed 3 people to the board. And with that, you had a full 5-member complement, right? So Noel Canning, the case itself, by the way, it's not a name, Noel Canning. It was a canning company named Noel, right? They were a Pepsi bottler in Yakima, Washington. It was like Noel Canning and bottling. People think it's a name. And they objected to these recess appointments. Now, what interest does a Pepsi company have in challenging recess appointments? The court may even mention this. A judgment was issued against them by these 5 members of the board. They argued that these members of the board were not properly appointed, therefore the judgment must be nullified, right? That's how this case came to court. You can't just go to court and say, the Senate broke their rules, right? The president broke, you gotta have an injury. And here the injury was that they claimed that the Senate did not properly consent to the appointments of these officials. It was not a valid recess appointment. The Court of Appeals actually agreed with them, much to the surprise of many. And this went to the Supreme Court. And the challenge was, were these appointments valid? The opinion was 9-0. And I want to just stress this, right? Very rarely do the justices agree 9-0 on a separation of powers question, right? When Justice Ginsburg finds that you broke the separation of powers, you really broke the separation of powers. You screwed up somewhere, big league, okay? But why does this matter? It wasn't really a 9-0 opinion. The 5 justices in the majority would have gone maybe halfway. The justices in the concurring opinion, basically Scalias dissent, would have gone much further. What the 5 in the majority said is, well, 3 days is too short, you need at least a break of 10 days to make a recess appointment. Scalias said, no. Go back to the text, right? The recess of the Senate. Vacancies that may happen. According to Scalia's reading of the recess appointment clause, unless a member of the board died during this recess, this 3-day recess, it can never be filled. And in truth, there's only one recess of the Senate. The period between one Congress meets and another. It's a brief recess. Now, what's the consequence of this? Presidents, for some time, were making recess appointments during the year. And presidents, for some time, were making appointments that arose before the recess. Under the Scalia approach, it would have rendered a significant number of appointments unconstitutional. Under the Breyer approach, for the majority, it would have more or less left everything as is. The only effect of the Breyer decision is that it would stop presidents from making appointments during these 3-day spans. Now, did Breyer specify exactly how long is a sufficient gap for recess? No, he said, well, less than 3 is bad, 10 is good, unclear what's in the middle. Now, why does this matter, my friends? Let me tell you how constitutional law actually makes a difference. Justice Scalia died in February of 2016, Saturday or Sunday, I can't recall. And immediately when he died, I had an oh shit moment. The Senate was in recess. I wasn't the first to realize this, but probably one of the first 5 people to realize this. Probably, maybe 10. But as I was grieving, I was like, oh, they're in recess. So I immediately checked the Senate calendar, and the Senate was actually due to be in recess for about 10 days. So I frantically made some phone calls to the Senate, people I know there, and I said, you need to come back in tomorrow. And ultimately, they extracted a concession from the Obama administration that if they promised not to make a recess appointment, they wouldn't have to bring everyone in. But he could have filled the vacancy with a recess appointment had he waited a little bit longer. I think he could have done it right away. It would have been a ballsy move for sure. But under Noel Canning, because Justice Breyer didn't really resolve one way or the other, the issue was open. But the effect of Breyer's opinion is, well, 3 days is probably too short, 10 days is just fine, Goldilocks, somewhere in the middle, right? Unclear. So let's walk through the opinions themselves. And what you have to know about Justice Breyer and Justice Scalia is that they were very good friends, but they saw the world in very different lights. Justice Breyer is what you might call a functionalist. His essence, his being, is how do we make government function more efficiently, right? He wakes up in the morning and says, man, how do we make government work better? That's like his reason for existence. He wrote books called Making Democracy Work. So he's, as a justice, is less concerned with the strictures of the separation of powers. He's more concerned to say, if Congress wants to do this, we should let them do it. Scalia's the exact opposite. Was the exact opposite. It was actually a very sad moment when I had to edit our case book and change all the Scalia is to Scalia was. It was actually a sad moment. But the Scalia approach is what's called formalism. It's the separation of powers exists to preserve freedom. This is Morrison, right? This is his dissent in Marcy Bilson. And I don't care what makes government work better. If government wants to work better, pass an amendment. Don't ignore the strictures of separation of powers. So this decision, perhaps more than any other I can think of, maybe top 5 at least, illustrates the differing approaches of Scalia and Breyer. And years ago, they would actually take a roadshow. They would go and testify before Congress and go to law schools and debate. And I'm very sad this camaraderie is not going to be on display anymore for a new generation of law students. One of the themes in Noel Canning was intransigence, this idea of gridlock, right? And Justice Kagan, I think, was a pretty good point. Why was a recess appointment clause originally created? Well, back at the time of the founding, people were farmers, right? To get to the federal capital from South Carolina or from Maine was a schlep. It took a while. And you can imagine that if the President's Secretary of War died during a recess, the President needed to execute the laws and would have to put someone in temporarily until the Senate comes back to town, right? That was the purpose of the clause. But in recent years, presidents started using it not as a way to get around travel delays, but to get around the fact that the Senate was blocking votes. So Kagan makes this point, which I think is very astute. She says, the recess appointment clause was not designed, is dealing not with congressional absence, but congressional intransigence, right? These recess appointments are working to get around the president and get around the Senate that won't confirm the nominees. And that's not the purpose of this clause, okay? The government lawyer, the Solicitor General named Donald Verrilli, gave a response to this that I think was wrong, but it was definitely their position, their considered judgment. He said, the recess power acts as a safety valve given that intransigence. If you know what a safety valve is, usually like a tea kettle, right, or a steam shuttle. when there's too much pressure, it lets a little bit of steam out, right? What the government's arguing is, look, the Republicans are being unreasonable. Why don't they just confirm our guys? Why are they blocking them? And because the president has the power of the recess appointment, he doesn't need to rely on Congress. The court unanimously agrees with that, right? They disagree with the notion that the Constitution is a teapot, and whenever there's any pressure, they go, well, teapot, right? Then they can just let some out. Get me over and pour me out. Justice Alito called that a very aggressive argument through executive power. And the reason why is that whenever the president decides that Congress is not playing ball, he can just sidestep them with the recess power. Today, it's of course invoked saying that the court should stop the president, but this was an argument that existed before 2016. And the prior administration took many steps to bypass Congress through executive action. So here, all 9 justices agreed that this went too far, right? The president can't just let steam out. And Chief Justice Roberts made a point that would be very relevant when it comes to Merrick Garland, and I quote this over and over again, because I know this stuff, is that the Senate has an absolute right not to confirm nominees. Now, why was this a personal lesson for John Roberts? President Bush 41, George H.W. Bush, nominated him to the Court of Appeals in like 1992. Senate Democrats never acted on it. They let it expire. So Roberts spent basically a decade where he should have been a judge and wasn't. He knows very well that the Senate has no constitutional obligation to vote a nominee. They have no requirement to do so. Okay? So this brings us back to the point of gridlock and Scalia, right? And even Justice Breyer, who's very much concerned with the separation of powers and making government work, says, what happened here with President Obama is a political problem, not a constitutional one. Eventually, the members of the board were nominated and confirmed by the Senate. They reached a political deal, right? So the fact that they were able to reach a political deal later makes even a stronger point that this bypass during this pro forma session was not appropriate, right? That Congress can indeed work if you let the process play out. Why? The president has a bully pulpit. In this case, he has a Twitter account, right? But generally, President Roosevelt was set to have the bully pulpit where he could speak directly to the American people. And this is a powerful voice. The president said, I have a pen and I have a phone, but the court pushed back against this. And this is the general sentiment, which people don't talk about much today, but was quite prominent in the last 8 years, that the president says, I take an executive action, we have a problem, Congress chooses to do nothing. And I emphatically reject the idea that Congress does nothing. If Congress doesn't want to vote on a bill, they don't vote on a bill. They don't have an obligation to support an agenda. There's no obligation to confirm a nominee. Poor Merrick Garland got screwed, but the Senate had no duty. And indeed, many people voted on the promise of not confirming Garland to the Supreme Court. Okay? So in some respects, gridlock is a byproduct of this disagreement. I would always give this statistic before the election, but now it's even more prominent. Every year, a survey is conducted asking people, would you be okay with your daughter or son marrying someone of the opposite race, right? So as you can imagine, in the 1960s, a lot of people were opposed to interracial marriage. Thankfully, I think as a mark of our polity, that number is going down, right? More and more people are okay with interracial marriage. Here's another question. Are you okay with your son or daughter marrying someone of the opposite political party? That is, if your parent is Republican, do you want your son marrying a Democrat? Or if the parent's a Democrat, do you want your daughter marrying a Republican? The opposition is going up. So while racial tolerance is perhaps dropping in this respect at least, political intolerance is going up. And this might be what's called partyism, and I think it's become even more galvanized since the elections, like I've last given this lecture. But Scalia, and I think he makes the point well as he does in Noel Canning, he says, gridlock is not a bug to be fixed, right? It's a calculated feature of our constitutional framework. This is part of our government, that when the branches do not agree, nothing gets done. And that is an important lesson to remember, especially important now. Okay? Because the president has his duty to take care that the laws are faithfully executed, but that's the president's obligation. Congress has no duty to pass laws. Okay? And I just want to show here. So this, again, gets to the point, the debate between Scalia and Breyer. Breyer generally says, if we adopt the Scalia position, the recess power becomes a dead letter, right? So unless someone literally dies during a 72-hour break, they'll never have to use this power. And Scalia says, that's fine. convenience and efficiency are not the primary objectives of our constitutional framework. For his perspective, it's checks and balances and ambition counteracting ambition. Okay? Okay, here's what I want to talk about here. So that's a general overview of Noel Canning. The opinion is also significant in the way it balances practice, right? Does the mere fact that Congress was doing something for decades make it constitutional? Right? This is Richard Nixon. I did it, therefore it's legal. What if I told you every president since George Washington was breaking the Constitution? Could a court come and say, George Washington was a crook? Or does a court say that practice, right, executive branch practice, basically doesn't amend the Constitution, puts a gloss on it. Imagine like lip gloss, right? You say that perhaps practice puts a gloss on the Constitution, and that courts can look to practice. And this is basically Jackson in Youngstown. There are very few clear answers, very few clear rules in the separation of powers. So one of the hallmarks is the president doing this, and does Congress object? That is, if presidents for generations have made these recess appointments, and the Senate never complained, that might mean those recess appointments are valid. In contrast, when the Senate, when Johnson tried to fire a Secretary of War, they impeached the guy, right? So the Senate knows how to take action when they get pissed off. But here, with these recess appointments, which run back 100 years, no action was taken. So for Breyer, he's very much looking to practice to define how we understand the constitutional separation of powers. Scalia basically says, we don't care, right? It was unconstitutional in 1789. It's unconstitutional today. Okay? Another point. What if the Senate says, we'll let the president do this because we're lazy, right? We don't want to have to hold a hearing. We'll just let the president make a recess appointment and be done with it, and then we'll deal with it later. Can one branch of government give up their power? Breyer is like, well, if they want to do this, they can do it. Scalia says, no. It's not for a branch of government to cede power to another, because that's how the separation of powers falls apart. One Congress can't bind the future one, and they can't forego it. So even if Congress for generations has not been complying with this rule, we can still come in and strike it down. As a practical matter, though, the recess appointment power has become a dead letter, right? Why? Because the Senate always holds these pro forma sessions when the president's party is not in power. So right now we have a Republican Senate and a Democratic president. I'm sorry. We have a Democratic president. That should be accurate. Trump is Republican and the Senate's Republican. So if anyone wants to get a recess appointment in, they'll get them in. They can just vote them normally. They don't have to go through the process. But in the last couple of years, President Obama, a Democrat, had a Republican Senate. They can just hold these 3-day recess appointments, these 3-day pro forma sessions, and you never get to 10 days. The Senate never actually goes into recess for that long. They always have these short sessions. So as a practical matter, the recess appointment power is dead. It doesn't really have much weight anymore. This is why I freaked out when Scalia died during the recess. Like, OMG. Like, I was frantically counting the count, like, 1, 2, 3, 4, but didn't happen. I lectured this case more than I like to. Do you have any questions on Noel Canning? Very, very significant case about how to apply text, history, and practice to separation of powers. So questions on Noel Canning?
So in Noel Canning, it was 9-0, but there was 5 and
Yeah. So
4.
so the vote breakdown is this, right? It was 9-0 that the recess appointments were unconstitutional. But 4 would go further and say that you can never make an appointment during an intra-session recess, right? So I'm going to give this. So you have this distinction between inter-session and intra-session recess. Intra-session is like the 72-hour break between the pro forma sessions, right? Inter-session is between the end of one Congress and the beginning of another. Most Congresses last a year at a time. So if you elect members of Congress for 2 years, there's one Congress and the second Congress. Under the Scalia approach, you can only make a recess appointment during this break between the sessions, inter, if the vacancy arose during that break. That's a very small time, might be a few seconds. So basically, it renders it a nullity. Under the Breyer approach, you can still make appointments during intra-sessions if it's at least 10 days, presumptively. He doesn't go that far, right? He doesn't actually say 10 days is enough. He says presumptively it's enough, which again leaves the issue open. So under the Scalia approach, I hate the number, thousands of recent appointments would be invalid. Under the Breyer approach, the only thing that's invalid is the recent one made by President Obama.
But also, I mean, from the power to fill the vacancies, the recess appointment clause, essentially, that appointment's only good for a year, right?
Up to 2 years, right?
Because it says the end of their next session.
Yeah, so it could be up to basically like 18 months or 19 months. It could be almost 2 years, depending how the math works out. So, I mean, if that's the case, the president can just appoint people for 2-year stints, one after the other, or never needs to go through the confirmation process. That's Scalia's argument, right? If we take this seriously, the president will never need to get the consent of the Senate. Getting consent to the Senate should be the primary path and not, his backup approach. Okay? And Scalia responds to this point about historical practice and said there's no evidence that Washington, Adams, or Jefferson filled any pre-recess vacancies. The evidence is very spotty, and I think Scalia points out rightfully that there may be some that run afoul of this, but without any contemporaneous explanation, they're not convincing of the Constitution's original meaning. Okay? Scalia's point of conclusion, which I think is worth reading, he says, the real tragedy of today's decision is not the abolition of the Constitution's limits on the recess power. It's the damage done to our separation of powers more generally. He says, it is not every day that we encounter a proper case or controversy requiring interpretation of the Constitution's structural provisions. Most of the time, the interpretation of those provisions is left to the political branches, which, in deciding how much respect to afford the constitutional text, often takes their cues from the court. We should therefore take every opportunity to affirm the primacy of the Constitution's enduring principle over the politics of the moment. Our failure to do so today will resonate well beyond the particularly disputed hand. When Scalia died, and I was counting days on the calendar, this passage was in my mind. I was like, he was right. The failure to resolve this means we have this issue left open. Yeah. Sad, but true. The court's embrace of the adverse possession theory of executive power. You'll say this in property. Adverse possession is basically squatting. If you keep doing something over and over again on a person's property, you own it. Right? You squat. Scalia says, the court's embrace of the adverse possession theory of executive power will be cited in diverse contexts, including those presently unimagined, and will be effective aggrandizing the presidency beyond its constitutional bounds and undermining respect for the separation of powers. I concur in the judgment only. Not I respectfully concur, I concur. Mic drop. So questions on Noel Canning? Yeah, Brittany?
So you think that in the future when we have another split again, that Congress is just going to make sure that they never take beyond 9 days now?
I can't imagine a circumstance this actually matters. I think generally the Congress takes short breaks and makes sure you never get to 10 days.
So because the court has never really defined.
They didn't give a bright
Because
line
they don't give a
rule.
really definition.
I remember talking to a reporter the day Scalia died. He's like, so what's the limit? Like, I don't know, ask Justice Breyer. 3, presumptively 10, I don't know, I was reading the opinion. So the failure to clarify these things matters when the issue arises in reality.
Because then Congress, I mean, is exactly, the Senate is always going to be in session because they don't.
Yeah,
'Cause they don't
but here they
have
actually were in session, they were in recess for, I think it was like 9 or 10 days, it was right in the cusp. But they made an agreement that there wouldn't be any recess appointments, but then boom, Scalia dies. Now you have this opportunity where it's like, screw our agreement, I'm going to appoint him now, he's in.
But because it's not clear, I mean, even if they were on break for 12 days.
What would have to happen is
The
someone would
court-
challenge a judgment issued by Justice Garland as being unconstitutional. It'd be a mess.
Yeah.
It'd be an absolute mess. President Obama did not do this. He probably could have. Maybe he got away with it, but he didn't do it.
If he had, how would they have challenged it?
Someone who is subjected to a Gorsuch ruling would have to challenge it, saying he lacked the authority to sit in the court. And his colleagues would have to recuse. I don't even know. It would be a
I
mess.
would say it'd be a mess. 'Cause
It would be an absolute mess. I think at that point you just accept it, you move on, you lost. Which is why I was making frantic phone calls to go back into the recess. Questions on Noel Canning? The appointment clause, the recess power, to summarize a little bit, are among the least appreciated but most important aspects of the Constitution. Simply because the president can't faithfully execute the laws by himself. He can't do it. He needs to have people, subordinates, who can help him execute the laws. Okay? But the consequence of that is, right, the consequence of that is you also need to be able to remove people who are frustrating that duty. What happens if the Senate won't allow the president to have the people he wants? Can he use a recess power to get around it? No. So the relationship between Congress and the Senate in this recess power and removal power and appointment power is very closely intertwined with the president's ability to take care of the laws are faithfully executed.
So really the whole, I mean, in present day society, the recess appointment clause has become more of a political weapon, less of
That's
less
Kagan's
of a
point.
constitutional.
Yeah, I mean, that's basically Kagan's point, right? What Kagan said is, I'll get that quote back. There. That this is not about congressional absence, it's about congressional intransigence, right? Intransigence means basically gridlock. You're not using this because you couldn't get the Senate back to Washington in time to vote, it's because they didn't want to vote. Right? You can get from Alaska to, Washington, D.C. in probably a single day's travel. It's not that hard. Back at the time of the founding, to get from, say, South Carolina or Georgia to the Capitol would take a couple days of travel. Maybe weeks, I don't even know how long it takes, but it took a while. Any questions? Anything in your minds?
So I guess I see like the only reason this becomes an issue or a constitutional issue is really if somebody tries to make a recess appointment in a small window of time.
Well, but it's not a recess appointment. It's an illegal appointment, right? That's the key point. The court said that these were, had they been during a recess, they would have been fine, but these were not during the recess. Right? So our class on Tuesday, which is the 26th, I can't count, focuses on the separation of powers. And you'll notice, for those who did your homework, I didn't teach this class last year, so it will not be any of your old outlines, and there will be a video beforehand. I'm teaching this for the first time. And I added it in response to current events. But it will ultimately be culminating in the questions of the president being indicted, and the president can be pardoning himself. I'll put some readings up later for that. Any other questions? All right, thank you so much.